Good afternoon and welcome to the Appellate Division, First Department. We have over 5 hours of argument time requested, so I will give you my usual speech. We are familiar with the facts, the record, and your case sometimes more than you wish we were. So please ask for only the time that you need, not the time that you want, understanding that the clock is for you, not for the court. So if my colleagues, because your questions are so wonderful, have more questions, I will let them continue over the time. All right? Let's begin. First case, People versus Randy Vasquez. Okay. All right, why don't we do 6 and 1 and 5. Rodriguez versus NYCHA. Okay. All right, let's do 5 and 2 and 5. Dania. All right. All right. All right, 5 and 2 and 2 and 3. BJ versus Schultz. All right. 4 and 2 and 5. Casanova versus Lopez. Submit. 823 Second Avenue versus Udica First. Okay. 5 and 2 and 5. Molema versus Citigroup Inc. And
If the court doesn't have any questions, then I'm fine with submitting.
that's fine with us. Submit. IKB International versus Morgan Stanley. Okay. Okay.
8 and 4 for cross appellate.
All right. Let's do 8 and 2 and 8 and 2.
Thank you.
All right. People versus Joshua Armstrong. Okay, and if we stand up, oh, you are standing, I'm sorry. 7 and 2 and 5. My apologies to you. Okay. Jacobson versus Cidio.
Good afternoon, Your Honor. 8 and 4.
Okay.
5 minutes for the.
Okay, 5 and 2 and 5. Ashanti versus City of New York.
Ellen requests 6 and 2, Your Honor.
Okay.
Responded 3, Your Honor.
5 and 1 and 3. Ortiz versus City of New York is submit. LHWS versus SL Green Realty is a submit. Wang versus Morano is a submit. First case on the calendar, People versus Randy Vasquez. You may proceed.
Good afternoon, Your Honors. I'd like to start with the second argument, the lesser included argument, because I think it's quicker. And here I think there are 2 key things for the court to consider. The first is that in this case, just a few small commingled bottles made the difference between misdemeanor shoplift and felony grand larceny. And here's the second thing.
Are you concerned that they didn't gather all the bottles, or they gathered too many? In creating the receipt,
I'm concerned with everything, Your Honor. In creating the receipt, I am certainly concerned that they gathered too many. If Your Honor is referring to the respondent's argument that they neglected to gather the ones that were in the store, I think 2 things. We're still talking about a difference between a handful of bottles. There's only a couple of bottles to the extent that we can even see in the video. And second, preservation works for both parties. That argument is entirely unpreserved. The court should not go there.
Maybe you need to explain to me just a little bit more clearly. Are you saying that there were items rung up on the receipt that shouldn't have been there, or what?
I think there was certainly the possibility that items could have been rung up on.
Based on what? Other than pure conjecture and speculation on your part, what evidence is there in the record that there was anything on the counter when the bag filled of stolen goods was brought in to be scanned for purposes of value?
Well, first, any limitations in the evidence regarding that are because the court cut off cross-examination. But two, in evidence is the fact that there were returns on the counter every day. It's not speculation to think if there were returns
Was
every
there
day.
evidence that there were return items on the counter that were cosmetics? Because all of the items stolen here were cosmetics, right?
Absolutely, Your Honor.
So was there any evidence? Any at all?
I think two things, Your Honor. One, again, court cut off cross-examination here. And two, the evidence has to be viewed in the light most favorable to the defense. In that light, it's certainly a reasonable conjecture.
No,
if
no,
there
wait.
returns
Is there
every day.
is there any evidence that on that day, did anyone testify on that day that there were returns on the counter?
If there returns every day, then there
No,
must
no,
be
no,
returns
but it
that
does,
day. But
sure, as a general matter, I'm asking you, is there any evidence, did anyone testify that day, either anybody who was there, that there were other items on the counter that?
Your Honor, trial counsel was trying to get there.
I'm just asking you whether or not there was testimony for that.
There was not because the trial court cut off cross-examination into that area. I think it would be very unfair to deny the jury the chance to decide whether this was just a
Can I
misdemeanor
suggest you
shoplift.
move on to your next issue, which I think has a little bit more meat on it?
Here, there's one key thing for the court to consider. Duvon sets out the absolute limit for what is tolerated for a show-up that is close in time and place. And here, we have a show-up that goes well beyond Duvon. Respondent quibbles with the individual indicia of suggestiveness, but I think the key thing is their cumulative effect. And together, they go far, far beyond Duvon. The first,
Well, counsel, since we're talking about cumulative effect, even if we were to agree with you that maybe certain aspects of the identification were unduly suggestive, why isn't it harmless error based upon all the other indicia, all the other evidence, particularly the video?
so in no case that we have submitted in the briefing when this court reversed because of an unduly suggestive show-up, has this court considered harmlessness.
Oh, no, that's not an accurate statement. I read a few of those cases last night, so that's not accurate.
I'm sorry, Your Honor. In our case, in the cases that we have
We have had
cited,
cases in this department where we say that the show-up was unduly suggestive, but in light of the substantial evidence of guilt, it is harmless. So whether you're familiar with them or not, they exist. Tell me why, whether this case falls within that.
I think if you got rid of the identification on the street and no evidence of that was presented to the jury, I doubt this case would be prosecuted, but the case going to the jury would look extremely
Let's look at what the officers have. We have a radio run, right, of a description that fits your client to the T, right? So there's no question. He's got on a red and white striped shirt, right? So the description of your client matches him to a T. And then the officers observe him walking down the street, kind of holding on to his pants, and cosmetics falling out from the bottom part of his leg, okay? Seems to me like that. And then they recover over 100 pieces of cosmetics from him, right? So it seems to me that those two things by themselves, together with the video, as my colleague referred to, could be sufficient for a jury to find that there's enough evidence there.
Could be. I would suggest that it's really for the second time around if this gets sent back down. And I would just like to state this for the record, Your Honors. We have presented a lot of cases where this court does not consider harmlessness in reversing undue show-ups. I think to go there subverts the idea that when you are looking at a hearing, you only look at the hearing. We submitted additional authority on this point last night. I think it would be error for the court to consider harmlessness in reviewing the suggestiveness of this case. Thank you.
You may proceed.
Good afternoon, Jillian Lewis for the People Respondent. Your Honors, looking at the video footage, it is clear that defendant walked into the Duane Reade, stole items from the shelves, shoved them down his pants that were tied at the bottom with string.
Can you just address the harmless, the harmless error question?
Yes, and that was addressed in the reply brief, and I submitted supplemental authority that I have copies of for the court for People versus Doctor, where this court found specifically that
While it has a holding that I understand why you like, the facts on that case are not really on all fours with this case.
Definitely.
But tell us your argument about, one, why you think that this ID was not unduly suggestive, and should we so find that it is, why even if it is, it's still harmless?
Yes. So the ID occurred in close proximate time and location to the act of the defendant going into the Duane Reade and taking the items. He was spotted after the radio run on the street, mere blocks from where it had happened, and within a 25-minute time span, officers came, collected the manager who had made the call. That was then, the information was transmitted on the radio run. He showed up with those officers, 2 officers, and defendant was at the scene. There were products there, but because it happened in real time.
But, I mean, let's stop there. I mean, one could make the argument that everything else you said, maybe the case law might support the fact that those things aren't unduly suggestive, but they could have just walked him a couple of feet away, a block away from where all the items that are alleged to have been stolen were right around him. Why isn't that so unduly suggestive that we need to consider it?
Well, this case has very specific facts in it, in that defendant used his pants to shove the items
It doesn't
down.
matter. People who steal use something that's on them. You don't showcase that something during the identification procedure, which is what happened here. And this, here, the witness who was doing the show-up ID was brought to the scene after the defendant was stopped. So there was certainly time, the same way they found the bag to put all of those cosmetics in order to go back to Duane Reade and scan them, they could have put them in the bag before the ID.
Definitely.
So,
And this court and other courts have found that show-up identifications are not the ideal form of identification, but here the officers did it in order to make sure that the suspect was the person that had just been seen in the Duane Reade. It was a way for them to...
you and I both know they didn't need to do that. He had cosmetics falling out of his pants,
Yes.
right?
And
So let's make sure that we make this procedure proper. Let's not taint it.
yes, and the officers could have removed the cosmetics, and that
they
might...
didn't.
And they did not. Correct. But even if with all of that, there is overwhelming evidence that defendant went into the Duane Reade, took the products, and those products came from the store. And there is case law that suggests that you can apply an analysis in order to find that even if you do find that the identification procedures here were not the ideal practice that you want others to follow, that this was sufficient and the jury had sufficient information in order to convict defendant.
Thank you.
Thank you.
All right. You have 1 minute.
And I have one point. Suppression is prophylactic. Law enforcement needs guidance from this court on what is allowed and what is not allowed. I think this, for all the reasons the judges are saying, there were many indicia of suggestiveness here. Law enforcement could have cleaned up the scene. They could have done a lot to make this show up less suggestive. And again, we think the court should decide on that basis, send this back down for an independent source hearing, and have a new trial.
Why? Your witness could not identify the defendant at the trial, so there's no need for I would normally agree that that would be the normal course. But here, the complaining witness could not identify him that many years later. So there's no need for an independent source hearing. We know that the witness cannot identify him anymore.
Your Honor, the show-up still came in at trial, and if there's an issue here, it's for the second time around for a new trial. That's our position.
Okay, so it's not for an independent source hearing.
Preceded by an independent source hearing to see if they can cure any taint. If the second trial goes the same way as the first trial, that's on
But
the
no,
people.
again, if your witness can't identify the defendant, how can we proceed with an independent
It
source
wouldn't be
hearing?
looking backwards, Your Honor. It would be looking forwards. There would have
So
to
he
be
has
a
a
new.
better memory of the defendant's appearance now than he did at trial?
If not, that's on the people to make their case. It's not on the defendant.
Okay.
Thank
Thank
you,
you.
Your Honor.
Rodriguez versus NYCHA. You may proceed.
Good afternoon. There are no material issues of fact in this matter. NYCHA terminated plaintiff because he was per se unqualified for his position as an elevator mechanic due to the revocation of his driver's license. He simply,
He also admitted that he never told any of his employers that he was a recovering alcoholic. But were there indicia that should have led them to understand that he was?
I don't believe that there were any reasons for NYCHA's HR department to infer or intuit that he was an alcoholic by virtue of his DWI.
What about his application and his participation in that program, the employee program?
His participation in the New York City Employee Assistance Program would not have conveyed to anybody the reason why he was enrolled in that program. First of all, I know that my adversary refers to it as NYCHA's EAP program. It's a city program. It's not NYCHA's program. But in the record, there's correspondence from the EAP to NYCHA that says confidential on top and does not in any point indicate why he was receiving any.
But I want to make sure I'm understanding the facts, right? So NYCHA becomes aware that he has a DWI arrest, correct?
NYCHA was aware that his license was revoked. The DMV informed
The
NYCHA.
city doesn't get notified when one of their city workers is arrested?
He was, yes,
Okay,
he was.
so
they were
the
also
city,
aware of
the
arrest.
city finds out, whichever agency you're in, that you've been arrested and what you've been arrested for, correct?
That's correct.
Okay, and then after that, NYCHA receives a letter from EAP saying he's participating in an EAP program. Sure, not, I wouldn't say exactly contemporaneous, but in short order. Am I right?
Different departments within NYCHA received each of those pieces of information.
And then after that, he then takes a leave of absence in order to participate in some kind of rehab program, right?
Apparently, but again, we did not know
And
that-
he can't do that without authority from NYCHA to take the time off, right?
the EAP
He
program.
can't just not show up to work and not explain why he's not at work.
The EAP program requested leave on his behalf and did not explain the reason for the leave. But again, this was several months before his license was revoked after he was sentenced to a 6-month, after he was sentenced to a DWI.
Right.
NYCHA didn't terminate him
Right.
upon finding out that he had a DWI
No, I
conviction.
understand.
They only terminated him because he did not have a
My
valid
questions were geared at trying to assess what did NYCHA know about his circumstance and his struggle with alcohol.
NYCHA was aware that there was a DWI arrest, but I don't think that you can
One doesn't mean
extrapolate
you're
from
right.
that,
Okay,
that you are either an alcoholic
right.
or that you are requesting an accommodation. And I think it's an unreasonable burden to place on an employer upon finding out that any employee is convicted of something, that they then have to initiate some sort of interactive dialogue, request information about whether or not they are an alcoholic.
Right.
Here,
And certainly no case law holds that.
no case law holds that.
So let me ask you, the EAP program, one could go into that for, say, depression or mental health issues having nothing to do with alcoholism or other, or drug use, or?
That's
right?
correct.
So
It could be any number of
anything.
things, and
right?
that information is not provided to the agent.
So when you say that the information was provided to two different, who got what?
He informed the, I believe, the Inspector General at NYCHA that he was arrested initially. This was before he was convicted, but when he was initially arrested. And the EAP program submitted a letter to the division of NYCHA's HR department that handles a leave when the EAP program on his behalf requested that he be granted leave, but did not ask, or did not explain why.
Was there a period of time post his termination, or pre his termination rather, I'm sorry, where he was actually performing his duties, maybe taking the bus places or being in one location?
His license was suspended upon his arrest, and it wasn't revoked until he was arrested in February. It wasn't revoked until September, which is when NYCHA found out about it. And so he was doing his job during that period of time.
So then he was doing the job for which he was hired. He was, how do you then say that he wasn't qualified?
Because the qualifications are set by DCAS, which is tasked with setting the job specifications for any civil service title. So he was per se unqualified because he was out of spec with his title when he did not have a valid driver's license. The title for elevator mechanic mandates that a driver's license be maintained for the duration of his employment. So even if he theoretically could have done his job, he was not eligible for the job, and therefore NYCHA treated him the exact same way it would have treated any other elevator mechanic who did not have a valid driver's license. And I think one important point to make is that had he simply produced a driver's license when NYCHA requested one, it would not have terminated him, irrespective of whether it knew he was an alcoholic or whether or not anybody at HR harbored certain feelings about alcoholics. It was purely because of his driver's license. He was treated the exact same way that any other NYCHA employee would have been treated.
Thank you.
Thank you.
You may
Good
proceed.
afternoon, Your Honors.
Good afternoon.
I think that Your Honors have identified a couple of key issues in this case. The first is whether or not the employer was on notice that the employee, that Mr. Rodriguez had a covered condition, was disabled within the meaning of the law. So I think everybody agrees that alcoholism, if you're recovering, is a disability under the law.
But what do you say to your adversary's argument that the fact that someone gets arrested for DWI does not automatically mean that they're an alcoholic? Sometimes people just had one glass too many and then drive and they get caught. That doesn't mean you're an alcoholic. So how do you address that issue? Because you will agree with me that your client did not tell anyone directly, I'm an alcoholic, I need help.
He told several people directly that he was an alcoholic.
His supervisor?
Yes, Jerry Massis. Now, my client stated at deposition that he did not recall telling Jerry Massis that he was in recovery for alcoholism, but Jerry Massis, at his deposition, my client's supervisor, said that he knew, that in fact, he had, I believe he stated that my client had told him that he was in recovery for alcoholism. He also told several of his coworkers. He also asked supervisors for an accommodation because he did not have, he could not drive. There was, because he wanted to stay at certain locations. Also, he did not drive between locations. So it's a bit of a left hand, right hand, where he reported as he was required to the Inspector General that he had been arrested for a DUI, and he went into the EAP program and his license was suspended.
So did he ask for an accommodation from HR or anyone who could have done that?
At the time that he,
Just, did he or didn't he?
I'm sorry, Your Honor, I don't mean to be cute, but he did when he went
No,
into
no,
the
no,
EAP program, but that's. one-
Okay, so the EAP program, he didn't say to HR, I'm in the EAP program because of alcoholism, did he?
That didn't come out during the.
Right,
the
he
deposition.
didn't, right? He didn't do it. And then he comes back and there's a requirement that he have a valid license and he doesn't have one anymore. At that time, does he say, I am an alcoholic, to anyone at HR, I'm an alcoholic, I can't get my license back, I need an accommodation?
He said to his,
No, HR, because his supervisor could be, sure, his friend. They could go out on Friday nights. But did he tell anyone who could have made that decision?
your supervisors and your managers who are agents of your employer are required to notify you if there's the possibility that you need a reasonable accommodation or would be eligible for a reasonable accommodation, and then talk to you about the process for
Wait,
applying.
you just said something that I think kind of turns the law on its head. I know of no requirement that a manager or supervisor has to advise an employee of available accommodations that might be offered under a given set of circumstances.
I'm not saying that the supervisor.
That's what you just said, though.
No, I said the supervisor has the obligation, if they know or should know that an employee might be entitled to a reasonable accommodation, to notify them that they can apply for an.
Again, what case law, what law says that?
It's the actual law, the New York City Human Rights Law and the New York State Human Rights Law. Under both laws, if an employer, and I believe the ADA, but that's not relevant here except as an analogy, if an employer knew or should have known that an employee needs an accommodation, they need to tell the employee that they might be.
Are you saying that he told his supervisor that he needed an accommodation, or that the supervisor should have said, I know you're an alcoholic, and from there, I think you might need an accommodation because you don't have a driver's license?
And if an employer did that, that employer would be subject to a lawsuit for calling an employee, I think you're an alcoholic. So again, you are trying to turn the standard on its head. An employer cannot say, I think you have this problem, and there is a way that we can accommodate you. The employee has to say, identify, I have a problem. I have this disability, I have this whatever, and I need an accommodation. So tell me where the onus is flipped on its head as you described.
I disagree with Your Honor that it's flipping it on its head, but the employee here did tell his supervisor that he was a recovering alcoholic. And I'm sorry.
Right, he doesn't recall that, right? He doesn't recall ever saying that. And I'm looking at the supervisor said, sure, I knew he was a drinker, I knew he was an alcoholic, but not, and the second part, which is necessary, which is, and he asked me for an accommodation, and I said, let's go to HR and do it.
Let's look at this from a different perspective then. Say that I injure my leg very, very badly, and I come into work and I have a job that requires me to take stairs, and I'm struggling up and down the stairs. So it's not going to be some sort of accusation that I'm an alcoholic in recovery, but it's a physical disability. And my employer does not say to me, hey, you can apply for an accommodation. And then we're required to engage in a process, in a dialogue under state and city law about whether there's an accommodation that would be appropriate for you.
Okay.
That doesn't happen, then what's the result? The employer is liable. It's a new or should have known standard, not an I asked for this specifically standard.
Okay, thank you. You have 2 minutes.
Just to respond to that last point, unlike a broken leg, being in recovery for alcoholism is not an observable trait. That's not something that an employer would be able to look at an employee and know. Here, NYCHA sent 2 letters to plaintiff informing him that he needed to show that he had a valid license.
That's what I'm curious. He gets a letter from NYCHA that says, you need a valid license. Does he go to NYCHA and say, I need an accommodation when he gets that letter?
He does not.
Does he say anything about the fact that he can't get a license and can he work here or there or anywhere else?
The only thing that he did was he submitted a request for an interlock ignition device.
Oh, right, okay, right.
And the ignition, an interlock ignition device is basically a breathalyzer that was required on his personal vehicles if he got a conditional license, which he didn't even have at the time. And so a waiver would have been NYCHA saying that he could operate a NYCHA vehicle without a breathalyzer. And HR didn't sign that because that could have been a major liability issue. But it certainly wasn't a reasonable accommodation request. It would not have rendered
So
him
someone who,
qualified at
right,
the
for
time.
example, someone who maybe had one DWI could have been, as a condition, could have had had to put up a interlock device, right?
Yes.
I mean, I recall that. So it's not, that's not necessarily indicative of alcoholism.
Right. I mean, anybody can drive while drunk, regardless of whether they're an alcoholic, but that wasn't a request for a reasonable accommodation of his alcoholism. It was a request for a future change in policy with respect to, his legal status. It had nothing to do with any purported disability, and nobody would have inferred that that was a reasonable accommodation request.
Thank you.
Thank you.
Thank you so much. Dania. You may proceed.
Your Honors, may it please the Court, my name is Amanda Abata, and I represent the appellant ACS. This Court should reverse the lower court's decision because there's no sound or substantial basis to return Esmail to his mother's custody. Although the family court properly found that the mother's use of corporal punishment posed an imminent risk of harm to the child, its conclusion that that risk could be mitigated was unsupported by the evidence. The family court found that it could mitigate the risk to the child by implementing safeguards, including a parenting class, an anger management course, random drug and alcohol testing, and directing the mother to avoid the use of corporal punishment and ensure that the child regularly attended school and enrolled in trauma counseling. But most, if not all of those—
Counsel, what was the record? How chronic was the physical abuse? Or was it a single instance, or was there more?
Your Honor, the evidence supports that it was more than a single incident, although the family court found that a single incident was enough to present a risk of imminent harm to the child. However, the family court also found that CPS Frazier's evidence was credible, and she testified that the child told her that the mother repeatedly inflicted excessive corporal punishment on him, and that was also demonstrated by his various injuries, which were in varying stages of healing. The programs that the family court tried to implement to mitigate the risk of harm to the child, they require some form of personal accountability that the mother did not demonstrate during the hearing.
Counsel, with respect to the injuries, there is the photographs, which are hard to look at, that show bruises at different stages, but do we need some kind of expert to interpret the color of the bruises for us, or the signs of possible bite marks?
Your Honor, I don't believe that that's necessary here because the evidence, the injuries, I believe that they speak for themselves, especially with regards to the child's testimony and CPS Frazier's testimony of what the child said, essentially that the mother had a practice of inflicting this excessive corporal punishment if he didn't obey the rules, that she would hit him with her hand or with a belt.
The point I'm trying to make is about the way the bruises present on the photographs. We can draw conclusions as lay people that they show perhaps an array of injuries over time. Is that correct?
Yes, Your Honor.
Is there any part of the service plan that the mother did not comply with that you offered?
Well, there are a couple of things. The service plan For example, it included parenting classes, and the mother presented evidence during the hearing that she'd already been going to those she'd already been attending parenting classes. But as the family court found, she then still lied under oath about the nature of the child's injuries and how the child obtained those injuries. Further, the mother said in her brief that she has no history of disobeying court orders, which is obviously not true with her prior history with judicial orders, where she has disobeyed several times some of the conditions that the family court was trying to implement here, including ensuring that the child went to school and ensuring the child has proper medical care for various conditions. There's also her failure to cooperate with ACS, which was demonstrated with the fact that at least within 2 months after the petition was filed, ACS tried several times to schedule meetings with her with regards to the toxicology screenings and a home visit, and she generally resisted in terms of that. And there's also part of the analysis here.
Counsel, may I ask you, the mom didn't admit that she hit the son on several occasions.
No, she didn't.
Right. She denied that.
She did deny it. And not only did she deny it, she told an implausible story where she said that the father came to the house.
That night, the night that,
Yes.
and he was the one who beat the kid.
Yes, and injured her as well as part of her story.
Right.
Is that the incident that's referred to in the DIR, the domestic incident report?
I believe so, Your Honor.
And
That
inside that DIR, it doesn't really mention anything about the child at all.
it doesn't mention the child at all, and also doesn't mention any physical violence from the father.
Right.
Has the mother ever tested positive on the random tests that she's taken?
No, Your Honor, she didn't test positive for alcohol in the tests that she did take.
The labs I saw didn't mention alcohol as a listed item being tested.
The allegations in the petition was related to alcohol.
No, I know that, but the lab, the first item on the lab was marijuana, cocaine, barbiturates. I didn't see alcohol anywhere in that list.
Fair enough, Your Honor, but she didn't test negative on the toxicology screen, so.
Okay. Thank you.
Thank you, Your Honor.
You have 2 minutes.
You said 3, I'm sorry, Joe?
You asked me for 2?
I asked for 5, sorry. But that's okay, I couldn't hear the time. I just want
All
to
right,
make sure I
I gave 2 and 3.
Okay, I understand now.
All right.
Good afternoon, Justices, and may it please the court. This proceeding is about credibility, and we have to, or rather this court has to assess what information, what evidence was before Judge Lewis when assessing Miss R's credibility. There's been discussion today and a question about not following prior orders. Those prior orders came up during the attorney for the child's cross-examination of CPS Frazier back in February 3rd, 2023, at the very beginning of the hearing that began January 9th. It lasts for 6 months, over 15 appearances. It's never brought up again. The family court never received any documents, and no one presented any further evidence concerning those prior orders. In assessing Ms. R's credibility—
I'm more concerned with the denial that she engaged in any corporeal punishment at all. Because her explanation for this child's old bruises, that they occurred on the night in question, don't hold water, not the photographs I saw.
I understand. And of course, the court doesn't have to make, and did not here make, a complete credibility or find that Ms. R was entirely credible. The court was balancing what Esmail had said at the CAC, the Child Advocacy Center, where he remarked, and this is not to minimize anything, that he had been in twice. Once that Friday, which was New Year's Eve, and once 4 years before. He calls it when he's 5 at one point, but 4 years before.
Please don't mention his name again.
I'm sorry, I'm sorry.
That New Year's Eve incident was the subject of the domestic incident report?
Pardon me?
It was the subject of the domestic, the DIR, that New Year's Eve incident?
Yes.
That's where she said how he got his injuries because the father came over and beat him.
Well, that they were—
That's what she said in her testimony, right?
That they both held on to the child?
She says she testified and she intimated that the injuries came from the father, not her, right?
She doesn't directly say that it was only the father. She says that in the act of both struggling over the child, that the child became injured, and she noticed that afterwards.
Okay. I don't think that's what her testimony reflects, but if you want to say that, fine. But let's look at the DIR. Inside that DIR, the child is not mentioned there anywhere, right? In fact, there's no physical struggle, violence, or anything. It's threats of banging on the door, ringing a doorbell, right?
I can't explain why the police did not include the child in that report.
So your testimony is that the police officers would have come there, seen an injured child, saw injuries, and not made a note of it in the domestic incident report, which is really their purpose for being there.
I'm making no judgment, Justice.
Okay.
I just can't explain why that happened that way.
All right.
Okay. Do you have anything else you want to say? Your time is up, but I'll give you another 30 seconds.
Thank you, Judge. I just want to address the questions that were some of the questions that were brought up, specifically your.
No, you ain't going to do that in 30 seconds.
No, I can't. The alcohol test, it's in the box on the right-hand side of the test. And it says
Okay, I'll take a
ethanol.
look at it again. Thank you.
All right, thank you.
Thank you.
May it please the court, John Newberry, appearing for the subject child.
Can I ask you, counsel, does the child, my understanding is the child does not want to go back with the mother.
That was the child's position at the hearing, and that continues to be the child's position.
Because it's the child's stated testimony or stated to the ACS worker that his mom gets drunk every Friday and beats him, correct?
Yes, that's what he told the caseworker. I think as various of your honors have tried to find out what was the regularity of this abuse that happened, and I think the child, in speaking to the caseworker, used sort of one metric to try and measure how often this happened. And when he was interviewed, I think some hours later on the same evening, I think it's January 4th of 2023, at the Child Advocacy Center, he sort of referred, that the metric he uses is whenever I don't listen to my mom, which happens very often.
Could be even more than every Friday.
Yes, so I think when you take those two things together, those two statements together, and consider them in their totality, which I think the court failed to do, this is happening with such regularity that it's hard for him to estimate. He's scared. He was scared then. He continues to be scared. It's obvious that he says, I cry when she does this to me, and then I go and I have some water and I return. But I think it's not clear to him why this is happening. There's no dispute that it is.
On the night of the domestic incident report, he said that his mom had beat him, correct? He didn't say his dad had done anything.
That's correct. In fact, he said that it was his father who had come over. Now, perhaps his father had been drinking, but on the night that we're talking about, and his father, and this is my client talking, became upset because he could see that my client had been beaten, and he was remonstrating with the mother, do not do that. And I think it's significant that there's nothing in the record indicating that she objected and said, oh, I didn't do anything. And I think, as your honors have pointed out, I don't think there's any credibility to assign to her version of what happened on that night, and I think it is especially troubling that she chose to, despite her history and despite all the services she may have gone into and participated in, that she is willing to come into court with this evidence, with these pictures, and tell the court, this is what happened. No, I don't bear any responsibility for this. So I think that really doesn't provide a sound, substantial basis for the court to, in effect, look, the court was concerned and put a lot of things in place, but it was premature without any demonstration that this woman had any insight into whatever was driving her to do this, to say, in effect, here's some services.
Did she ever admit that she hit the child?
Not on this record. To go and do some services and just, don't hit him. I mean, that's a flip way of how I read, from my client's perspective, the order of protection. That's just not sufficient on this record. So we ask you to reverse. Thank you.
Thank you.
Your Honors, I just wanted to address 2 points. With regards to that domestic incident report and my colleague's response, the mother testified that when she allegedly called the police, that she told the police everything that happened that night, And so we have to take it based on that everything that she told them was memorialized within that domestic incident report. And finally, with regards to her prior history with ACS, there was evidence given at the testimony, and the family court was aware that she had a prior history with ACS. And we also included a lot of that in the attorney for the child's brief, and also in our reply brief, and of course, your honors could take judicial notice of that.
Is there a custody I know custody is coming up, that the father has filed for custody, but at this moment, does the mother have custody?
No, the child is with the father at this moment because there's a stay.
No, I meant like, was there a custody order? I know he's with his father right now.
Okay.
But was there ever a custody determination?
There's no evidence of that I'm aware of in the record.
Thank you. BJ versus Schultz. You may proceed.
Good afternoon, Your Honors, and may it please the court. Summary judgment should have been granted in this case for two reasons. First, plaintiff's expert affirmation was insufficient as a matter of law because their expert deliberately disregarded the testimony of the operating surgeon and repeatedly misstated the facts and evidence in this case to create feigned issues of fact. Two, the injury that occurred in this case was a known risk of a highly complex and necessary surgery. Beginning with the first point, plaintiff's expert affirmation should have been found insufficient as a matter of law because plaintiff's expert repeatedly criticizes our client by refusing to accept his testimony as to what he did. And the reasons for which their expert says that he gets to reject our client's clear and unambiguous testimony as to what he knew and what he did are entirely fabricated. They're not based on the evidence.
Did we draw any kind of negative inference against Dr. Schultz because it was Dr. Gomez that discovered the injury?
No, Your Honor, because as our expert explained, due to the difficult anatomy of this patient, it's very difficult to see what you're doing, and the area was so compressed that the typical sign that an injury had occurred would be that you would see CSF fluid leak out, and that was not seen because the area was so compressed within millimeters, a literal hair's breadth.
But it started out that way, so where you have a compressed disc on a child with spinal bifida that is so torqued, right? You're not likely to find much fluid left in those discs anyway, so that on this record, I don't see how that is something that he should have expected as a sign.
Yes, Your Honor. I'd like to also address this question by just pointing out that this is not an alleged departure by the plaintiff, that there was any delay in identifying the injury. That's not a claim in the case.
What about the plaintiff's expert indicating that the instrument, the Bovie instrument, was not the appropriate instrument that should have been used in this procedure given her anatomy?
Your Honor, you're correct that the expert initially says that. However, that expert later says on page 3134 of the record, the standards of good and accepted practice require that Bovie cautery carefully be used where posterior elements are absent or in approaching the dural sac. Their expert conceded that you can use the Bovie cautery carefully and safely. They then needed to show how our client used the Bovie cautery uncarefully, and they did not do that. They just say an injury occurred, therefore there must have been negligence. But this is an extremely high-risk surgery where nerve injuries are a common complication despite best practice.
No, wait, doesn't the plaintiff's experts say that Dr. Schultz failed to appreciate the complexity, the extreme complexity, and therefore use the bovine in proximity of the dura, which was contraindicated? I mean, I don't know if that's true or not, but that raises an issue of fact.
It does not, Your Honor, because that is a feigned issue of fact, because plaintiff needs to have a basis for their opinion, and I'm glad you brought that up, because I'd like you to direct you to the record in pages 286 to 288, where you'll see that plaintiff claims that those pages are what allows his expert to ignore Dr. Schultz's unequivocal testimony, where he said, I was aware of the missing posterior spinal elements. He said that. But they say, we're not going to take his testimony at face value because there's this contradiction in the radiology report. But if you
Because
look
of
at
the
those pages,
S1, S2 levels, right? He says, I'm going down to the S1 level, but then goes down to the S2 level?
that's a separate issue where, again, they're trying to establish a contradiction, but it is a feigned issue of contradiction because on the question of was he supposed to be operating on S2 level, it was always the surgical plan to expose below the area. And we know this for two reasons.
Yes, but it's the way I read the expert, this was one of the most clear quintessential battle of the expert cases I've seen since I've been here. And I don't agree with you that the doctor is ignoring. He doesn't agree, right? And that's what an opinion is about. And he explains why he doesn't agree, right? And he says, the way I read it, yes, they were ultimately to get to S2 because they were going to do some pinning there, right? But how you get to S2 was the question. And it seemed to me that the expert seemed to indicate that the instrument he used to access all the way down to S2 was not the instrument he should have used and should have stopped short of that and gone in more manually than with the machine.
Your Honor, what he says is that you should not have done extensive dissection at the level of S2. He does not establish that Dr. Schultz did extensive dissection. He doesn't identify what extensive dissection means, and he doesn't identify alleged departures.
So, counsel, let me ask you, is the Dr. Schultz's operative report says I went into S1, correct?
He says he exposed down.
Did it say anything about going down to the operative report, down to level 2?
No, Your Honor, and
No,
that's because.
and then later he testified, oh yeah, I went to level 2. That's not in his operative report, correct?
No, but it is in his preoperative note, and I direct you to look at page 1622.
Already there are discrepancies between what he's saying in his operative report, what he's saying in his preoperative report, what he's saying, and that whole question of whether to use that instrument down there to the extent that your client did. Isn't that the whole crux of the case?
No, Your Honor. No, Your Honor. May I respond?
Okay.
Yes.
So it was always the plan to expose below S1. And it's not just him saying this in his testimony where he unequivocally explains why he needed to do this, which our expert said was proper. If you look at page 1622 of the record, as part of his informed consent discussion with this patient, he explained that the instrumentation may need to extend down into the pelvis, which is below the sacrum, which is what the S stands for, these S levels. It was in the preoperative workup that this was part of the plan. This is not an ex post facto explanation. That is an example of they're just making things up to generate questions of fact, and they can't do
All right,
that.
you'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. Brian Isaac. I represent the plaintiff respondent. I don't think we made anything up. I think this is a quintessential issue of fact.
Let me just ask you,
Bring the mic up a little.
is there anything, does the operative report say, and yes, I went down to S2?
Of course it doesn't. That's what our expert said. But here's the funny thing. This is their explanation for going, this is an L5S1, as you know, fusion. You don't have to go to S2. This is their explanation. I want to read it to you because I think it's incredible. And this is 312, 313, 333. I'm quoting. We went to below the S1 level, quote, so that we can safely perform the operation and have adequate room for our hands, putting screws first, close quote. And because, quote, we also considered instrumenting to the pelvis, which would further require dissection distally, although we ultimately decided not to do that. This large hand theory doesn't make any sense because, as our expert said, Dr. Gomez used instrumentation to do the dissection at the laminectomy site at L5S1. And why in God's name would you use a quartering device that's 350 to 500 degrees on exposed bony prominences without knowing whether you were going to do it first? Forget about medicine. It doesn't make any sense. And our expert said 5 times, that this was a deviation from accepted practice. The use of this device in this child was a deviation from accepted practice. Now, my adversary said to you and in the brief that there was a concession made by my client. With all due respect, Your Honors, it's just not so. if you look at 3127, I'm just going to give you the basic outline of what our experts said. It's the 15th line down. Therefore, the standards of good and accepted practice require that bovie electrocautery not be used on the dural sac and or nerve roots under any circumstances at any level. He's referring to the fact that the bony prominence of this 6-year-old girl was exposed at S1, S2, and S3. My adversary then asks you to read 3134, paragraph 15, I think it's line 12 also. This is what he says. Therefore, the standards of good and accepted practice require that bovie electrocautery carefully be used where posterior elements are absent. You can use it, but not at the site where there's an opening which exposes the thecal sac, the dural sac, and the nerve. And then he says this, and I'm going to quote exactly. Posterior elements are absent or when approaching, that's the key word, approaching the dural sac and or nerve roots at any leg. This wasn't approaching anything. This was there. And this was severed 3 ways, 6 ways, and he didn't even know about it. It was Gomez who found out about it. And one other point, and I'll sit down. Every single physician, doesn't matter if they're not defendants, non-defendants, or experts, say that in this anatomical scheme, it is exceptionally dangerous to do this. You need what, quote, extreme caution, according to Dr. Schultz. He didn't use extreme caution here. This is a summary judgment motion where the trial court granted a bunch of dismissals on some of our claims. I think they did it correctly and also denied appropriately as well, and we'd ask you to affirm. Thanks.
Thank you. You have 2 minutes.
I'm grateful for what plaintiff just brought up because he explained neatly for me the problem with this case. What he just read, that line from his expert, was that it was inappropriate to use the bovie cautery on the dural sac or the nerve roots. That's saying that Dr. Schultz intentionally cut the nerve root would be improper. Of course that would be, but that's not what he did. There was an inadvertent injury to the area which is a millimeter away from the area that it is undisputed he is supposed to be cutting. He is supposed to be exposing up to the dura. The fact that an injury occurred to the dura, which once again was the only thing this court, the only evidence he shows this court as to how he knows he did it improperly, was that there was an injury. That injury is a known risk because it is unavoidable when you're cutting within an area that is within a literal hair's width. This injury can happen even when you are operating carefully, and the existence of the injury is the only thing their expert says was done wrong. They don't say how he should have used the bovie cautery more carefully when cutting. He conceded that you can use that tool. He just says you should have done it carefully, and then says you didn't do it carefully because there was an injury. That's not good enough in a medical malpractice case when it's a known risk that is undisputed.
Thank you. 823 Second Avenue versus Udica First. You may proceed.
May it please the court, Michael Panayotou, Melito, and Adolphson for the appellant. The Supreme Court's order should be reversed, and the court should declare that Udica First has a duty to defend the landlord in the underlying action. I want to address 2 points. The first one's a threshold issue. There really should be no question that the landlord is an additional insured. The landlord is specifically endorsed in the policy as such. The lease requires the tenant to procure such an additional insured coverage for the landlord. The lease provides that the tenant has to keep...
Counsel,
yes.
Assuming we agree with you on that issue, why don't the exclusions apply here?
Well, the exclusion that Udica First is relying on, the employee exclusion, doesn't apply because Udica First only disclaimed to the tenant, PR Crepe Limited. They did send the letter to its insured and also to the landlord, but the
You got two letters on adjacent days. November 11th, they disclaimed coverage to your client, right? And then November 12th, they explained why. I mean, weren't you on notice that they were going to invoke?
Well, Your Honor, the first letter was a disclaimer based on the terms of the additional insured endorsement. It stated that there's no coverage unless PR Crape, who's the named insured, is legally liable because that's the scope
Yeah,
of the
but then
additional
they,
insured
on page,
endorsement.
on record 239, then they have a saving clause saying the aforementioned discussion of this policy provisions is not designed to be exhaustive and is subject to reevaluation. So the next day comes what could arguably be the reevaluation invoking the provision that they're relying on.
I understand that, Your Honor. I would argue that the letter is pretty specific, that it's being directed to PR Crape only. It says the purpose of this letter, and I'm reading from 302, which is the disclaimer, is to advise PR Crape Limited, DBA John's Restaurant, that there is no coverage available to it for the accident and for any claims and or suits against it relating to Rafael Machuca Hernandez's bodily injuries. So when an insured reads this letter, it's a big reach for the insured to be able to understand that they're claiming additional insured coverage to the landlord as well, because it does say singular it, and it also concludes later on page 303, in view of the foregoing, Udica First hereby denies coverage to PR Crape Limited, DBA John's Restaurant, for claims arising out of the injuries. So our position is that the case law supports that the disclaimer needs to be specific. We cite some case law where, in fact, Udica First actually had a broader language in the disclaimer. They said there's no coverage to any party. There's no coverage to any insureds. So it's very clear they're speaking to just not the named insured, but any other potential additional insureds. They didn't do that in this case. So respectfully, I think that the order should be reversed and the court should declare. Again, we're talking about just the duty to defend here, not indemnity. So the issue of whether PR Crape is legally liable isn't for.
Well, counsel, didn't they quote the employee exclusion?
They did quote the exclusion, Your
So,
Honor.
I mean, if you quote the employee exclusion, what else do you think you have to say?
Well, I think that they need to specifically state to the putative additional insured, which is the landlord, that there's no coverage to the landlord as well, because the landlord receives one letter that says, well, you only get coverage to the extent that PR Crape is legally liable for the claim. Well, there's a third-party action going on. If
So you're saying the fact that you were CC'd in the letter means you didn't know that they were disclaiming coverage? I mean, you got that letter the next day, right?
we're not disputing that. Yes.
Right. So, and the letter says we're disclaiming coverage under the employee exclusion, right? And that's an exclusion that applies, correct? Or you don't think it applies?
Well, even if it does apply, Your Honor, I
It
think
applies. You got the letter. You know that you're excluded. So where is the reversal here?
well, we do cite cases that the Shell versus Fireman's Fund on page 11 of our reply brief, Valiant versus Udica First. You need to the insurance company needs to specifically state to not just the named insured, but to any other putative additional insured that the disclaimer applies to them. Otherwise, the disclaimer is limited to the grounds stated in the disclaimer. That's Shell versus Fireman's Fund. I think it applies here to where it could be reasonably concluded that the only restriction on the landlord's coverage is if PR Crape is not legally liable for the claim, because that's the scope of the additional insured endorsement. And that, of course, isn't going to be determined until there's a finding of fault in the underlying action. But in terms of defense obligation, there should be a defense obligation for the additional insured, the landlord. If there are any other questions, I'll just save my rebuttal time. Thank you.
You have 5.
Good morning, Your Honors. Lester Channon from Farber, Brox, and Zane for Udica First. I agree with the points of view of some of you who have spoken up on this issue, which is that it's a very just a very straightforward.
Yeah, but why 2 letters? Why make it harder on yourself? Why not just do the letter and send it to the person, you know?
Admittedly, they could have drafted it better than they did, but they did what the case law requires them to do, which is 1, quote the exclusion. Some of these cases don't even quote the full exclusion. Some quote it to the named insured, but not to the additional insured. And second, it showed the exact facts that apply, that this happened to an employee of an insured, and it explains that it happened in the course of that employment. Those are the only 2 elements that have to be satisfied for this employee exclusion to apply, and they clearly did. And the
What
case-
about the part of the agreement that says that it doesn't apply if there's some sort of incidental contract?
I'm sorry, I have a little bit of a hearing disability. If you could like shout, that would be great.
Okay, I was referring to the, where it says exclusion 8 does not apply to liability assumed by the insured under an incidental contract.
That is an exception to the exclusion, and we spent 10 pages in our brief explaining why Williston and a bunch of other treatises and
Your adversary is saying the lease is that incidental contract. Why is it not?
why is this not an, well, it is, there's a lease involved, but it requires.
Why does that lease, let me ask the question better. Why does that incidental lease not change the narrative here?
Right, the application. Because it applies only if they assume, it applies to an insured's assumed liability. But here you have the landlord who didn't assume any liability, therefore the assumed liability of the landlord, 823 second, has no application here. And so we explained that at great length, and my adversary chose to not respond, and we take that as an abandonment of that argument.
So the purpose of that section was just to carve out an exception for Crape's indemnification duty, right? Did you hear what I said? I'm sorry.
Well, but it says the insureds, so it has to apply to the specific insured at issue here, which is the so-called additional insured.
Right, but it does have meaning in that it applies to the initial insured, which was Crape.
Yes, it most certainly does. I mean, it applies to their contractual indemnification obligation, but in this particular case, that's not at issue. The additional insured coverage for the landlord is at issue, so it doesn't apply, and they apparently don't dispute that, having not responded to our lengthy discussion on it. Okay. I could talk about the additional insured issue as well, but I don't know if that's necessary. It's pretty attenuated. The lease speaks about leasing a corner restaurant at this particular location in a building, which is defined as the premises in the complaint. Landlord's responsible for structural defects. Landlord's responsible for the maintenance and repair of all public areas in the building. We don't know where the accident happened specifically. Did it happen in a public part of the building? That's unspecified, and we can't.
He fell down the stairs going into the basement.
Some stairs going down to the basement, which was, based on the lease, a shared space. So does that mean the landlord was responsible for the stairs? We don't specifically know that, and it's our position that it's too attenuated to show that the accident was proximately caused by at least in part, by the acts and omissions of the restaurant. And so, it's a closer argument, I think, but the exclusion argument is a very, very strong one as we see it.
Thank you so much.
Thank you, Your Honor.
Your Honors, I'll just say briefly that the allegation is that the claimant tripped, and was injured. The lease provides that the tenant is supposed to keep the premises in a neat, clean, sanitary, and safe condition, and to keep them free of debris. I think that's enough to trigger the duty to defend here, or with respect to the additional insured endorsement. To respond to what my adversary said concerning the letter, he said it could have been better drafted. I think it needed to be better drafted. I think the letter needed to specifically say there is no coverage to the named insured, quote, or any other party, as part of the case law we cited in the Valiant case, pages 11 and 12 in our reply brief. Another case from the Eastern District, which was interpreting New York law. The disclaimer was held to be appropriate because it denied coverage, quote, to any to any other person or entity who would qualify as an insured or additional insured. That sort of broad language puts the additional insured on notice that they would not have additional insured coverage. The disclaimer here, it's our position, did not do that, and that's why we request that the court reverse the decision below. Thank you.
Thank you. IKB International versus Morgan Stanley. You may proceed.
Thank you, Your Honor. Jim Rohonda of Davis Polk and Wardwell on behalf of Morgan Stanley. I'll address the Champerty issue first. The court erred in 4 ways. First, the IAS court disregarded the evidence of IKB and Rio's intent and purpose. And in fact, the decision didn't even mention or consider the evidence of the intent or purpose, nor did the court cite any evidence from IKB or Rio that there was some other purpose besides litigation for the assignment. And in fact, they have never identified any evidence of an alternative intent or purpose. So the court didn't undertake the necessary analysis. And that evidence was simply overwhelming. It came from lawyer declarations, in-house lawyers, outside counsel. It came from written discovery responses. It came from briefs on the motion to compel. It came from a brief in opposition to our summary judgment motion, and it was ignored. And it repeatedly said that the purpose of the assignment was litigation, and frequently it said the sole and singular purpose was litigation and that there were no other business concerns.
Does it matter that the party to which the claims were assigned were no strangers to this whole transaction? I mean, at some point, they had interest in loans that were given out. I mean, it's not as if this is some kind of debt collection agency that just swoops in. This is someone, or a company rather, that has some sort of relationship.
No, it makes no difference because that's not in the statute, which is, by the way, a criminal statute. It's not in the Court of Appeals decision as an exception. And in fact, on appeal here, I think IKB has abandoned that argument. It's not even defending what the court below said on that. It's not the test because Section 489 says nothing about being a stranger. The Court of Appeals has not recognized the stranger test. This court has not. And they concede that on appeal, being a stranger, this is at their brief at page 39, being a stranger is not part of the test for Champerty. It's just what they say, a shorthand.
Yeah, it's a shorthand for retaining an interest, and which is what they argue here, that they retained an interest in the proceeds from the certificates, the 20/80 split, and that Rio just didn't have the capacity to bring litigation, and therefore it had to retain that interest. IKB had to retain the interest to bring any litigation arising from them.
Right, so the pre-existing interest is incorrect too. That ruling, that was the 4th way in which I believe the court erred when it said that IKB had a prior interest in the, quote, subject matter of the lawsuit. There's no such test. It's vague, it's unprecedented. And in this case, what the courts have said is if you have a pre-existing interest in a debt instrument, you can consider that in determining what the primary purpose test is. It doesn't alter, it's not an exception to the primary purpose test. It's you can consider evidence as to whether there was a pre-existing debt instrument, and it's not an alternative, but it's not relevant here.
Weren't they the first purchasers?
I'm sorry?
Weren't they the first purchasers?
No, they were not. IKB SA was the initial purchaser. IKB AG is the plaintiff here, and they were not the purchasers of the certificates.
And one
they
is
didn't own the certificate.
But one is a subsidiary of the other, no?
One is, yes, they're related. They're related, yes.
So, I mean, we're talking apples and oranges then, aren't we?
AG owns 100%, right?
I'm
Does
sorry?
AG own the IKB SA?
I believe they did at one point, but it's irrelevant because there's no test that, if you could simply say, I'm going to assign it to somebody else in the corporate family, and they're not a stranger. There are companies out there with hundreds of subsidiaries, and you could take one and just transfer it to some subsidiary that has nothing to do with the investment. Here, they had nothing to do with the investment, but they didn't own, So the standard is there a
In Justinian, the court recognized that, and following Moses, which had been the law of the land for over 100 years, right? Said, we endorse the distinction in Moses between acquiring a thing in an action in order to obtain costs and acquiring it in order to protect an independent right of the assignee. Isn't that what's happening here?
No, it's not, Your Honor, with all due respect. They didn't own the certificates, and Rio owned them. They had no right to receive, they weren't doing this to receive interest and principal on those certificates. And with respect to the loan, they're now saying that the pre-existing interest is a 2008 loan. That loan was not a pre-existing interest at the time of the assignment. It was paid off in 2011. This is in their annual report to shareholders, 2010, 2011, over a year before the assignment. IKB publicly disclosed to its shareholders that the loan had been repaid early. This is at the record 3636-37. The loans assumed by the special purpose vehicle Rio to finance the purchase price as a whole have now been paid back ahead of schedule. Now they say, well, but there was $1. There was $1 outstanding on that loan.
Well, but there were also potential returns from the litigation, which will remain to be seen, but...
No, with all due respect, there were not, Your Honor. There was no intention.
From this lawsuit, I mean, if they win in this lawsuit, don't they have to divide some of that or give some of that to Rio, or am I mistaken?
Yes, as a result of an agreement that occurred after the assignment in a supplementary deed. Okay. It wasn't pre-existing. In fact, when the 2008 loan was made, there was no thought of a recovery on the loans. In fact, the Rio's corporate representative said, and this is at the record 3523, that we acquired the portfolio back in 2008. It was never the intention at the time that Rio was acquiring the right to pursue claims and damages against the original originators. We acquired the portfolio with the intention of recovering principal and interest. It wasn't until after, it's not pre-existing, this dollar was, they didn't do this assignment in order to protect the ability of Rio to pay them $1 back. And we know that because the agreement didn't permit Rio to pay back that dollar. That's not, first, as ridiculous as it is that it was $1, there was no ability to take the proceeds and pay Rio back the dollar. They had to consent to it, even if they had the money. And it was the supplementary deed that comes after the assignment. It comes 8 months after the assignment. It's after they file the case. It's 2 years after they've paid off the loan. It's just simply not pre-existing. And what they tried to do is they said the supplementary deed will make it effective as of the assignment date. Not, they couldn't do it pre-existing. But all you need to know is they tried to make it effective. If they had a pre-existing right to an 80-20% split, there would have been no reason to have a supplementary deed that supplied that. In fact, the supplementary deed is the document that said we're going to treat this the way we treated recovery on the certificates with an 80-20 split. But that didn't pre-exist. That came into effect after the assignment here. So it was not, as a factual matter, there was nothing pre-existing about it, and it was nothing other than a $1 repayment, which was already, which they couldn't have repaid in any event. So,
all right, you'll have time on rebuttal.
thank you.
If it pleases the court, John McFerrin Clancy for the IKB plaintiffs. Your Honor already took my lead point. The standard is not whether there was an intention to, every assignment of claims, someone intends to litigate them. The question is why? To profit from the litigating or to protect a pre-existing right? Let's get to the facts on the pre-existing right. Under the loan agreement that was entered into 2008, IKB had a, the loan, the way the loans worked is the senior loan would be paid off, the mezzanine loan would be paid off, and then IKB's junior loan would be paid off to $1. And then it would receive 80% of residual interest. That's at the record, page 3581 in the junior loan agreement. What's residual interest? Well, it's defined as, these corporate agreements, It's defined as 80% of the company receipts. And what does company receipts mean under the junior loan agreement? Collections in any other income or proceeds received by Rio. And that's in the record in the junior loan agreement at page 3570. So from 2008 on, IKB always had an entitlement, once the loan was paid off to $1, as counsel points out it was, they always had a right to 80% of any proceeds that went into Rio. Now, that is a classic pre-existing interest. Notably, under the assignment where IKB, in 2012, when IKB gets the assignment of claims, it gets $0 for litigating the claim. And in Justinian got 15% if they prevailed. In Rich Bell, there was supposed to be a premium up to 20 times what the funders put in. Here, when you look at the assignment, which I believe is at record 1819, you'll see IKB turns over all the net proceeds. After it gets back disbursements, all the proceeds go to Rio. IKB gets $0 from litigating. Why? Because in the back end, in the distribution of proceeds from Rio, there's this 80% interest, 20% to the mezzanine lender. So had there never been an assignment from Rio to IKB and Rio brought the claim, IKB would have gotten the 80%. All right, so at the end of the day, there's really no fact issue. The only reason for IKB to take on this litigation was to protect its pre-existing interest from 2008 in the 80% of the proceeds that flow into Rio. And if you look at the cases where summary judgment was granted or denied, in Justinian, which the court called a sham transaction, Justinian was just making money by going around and getting 15% of the litigation proceeds.
Counsel, should we shift to the fraud claim?
I beg your pardon, Your Honor?
You're cross-appealing on the fraud claim?
Yes, thank you, Your Honor. With regard to that,
Yes, Your Honor, sorry.
I think the principal, error, respectfully, that the IS court made was saying, well, this is just a redux of your fraudulent concealment claim, which was dismissed way back when by Justice Friedman. But it's not. It is a misleading statement claim, meaning that there's a duty to disclose when your statements are otherwise misleading. And I think the best case for this, as this court discussed in the ACA case, which is where there was a CDO, the Goldman set up, and it represented to investors that Paulson was going to be the sponsor of the CDO. And as this court noted in that case, the market understanding was that the sponsor was supportive because it took the first loss on in the CDO if the CDO went belly up. Secretly, though, Paulson was bidding against this, and Goldman Sachs knew this. He had set up the CD hoping that it would fail, the CDO hoping it would fail. This court said that after remand from the Court of Appeals, this court found that saying to the investors, Paulson will act as sponsor, but not revealing that, oh, but he's not going to be like the sponsor you guys know. There's going to be a, quote, stark departure from what everybody understands a sponsor to do because he's bidding against it, was sufficient to state a fraud claim, wholly apart from any fiduciary duty or special relationship.
Counsel, the IKB had certain investment guidelines for their managers. How does that play into your position?
Minimally, Your Honor, because what the investment guidelines are is not, here's what I want you to do. Here's the kind of detailed analysis I want you to perform in order for you to invest. These are broad guidelines that say, I want, say, a certain percentage of my portfolio to be AA, certain percentage to be BB, and just make sure everything is above investment grade. And here, you can invest this percentage of the portfolio in assets backed by residential mortgages, this percentage by credit cards, et cetera. Those are the investment guidelines. They don't direct BlackRock or Standish. That's why we're hiring them, and how to perform their function. So on this case, so what happened here was the defendants would say, well, here are a bunch of mortgages that were originated by, say, accredited.
So, counsel, may I interrupt you just for a second, please, and ask you specifically what you are saying the misrepresentation is?
Exactly.
What is specifically, and what document is it? Where is it? I mean, it's not like, hey, we thought they were looking. You can't I think we would both agree, you can't say, you know, we relied on them to do their job is the misrepresentation. So I'd like you to just directly tell me what you think, where, in what document is the representation, and how was it a misrepresentation?
Two things, Your Honor, two categories, I'd say. The first is the representation that, for example,
Where,
in
what
the offering
document?
materials, in the offering materials, in the term sheets, they identify the different originators of the loans.
So you're saying that you relied on a representation of who the originators were?
Just as, you know,
Again, I just need you to tell me, is that
That
was a
when-
material misrepresentation and that you relied on it?
material misrepresentation there is that when you tell me that accredited is originating the loans and you know they're not complying with their origination guidelines, you have a duty to come forward.
But wait, you've just leapfrogged two assumptions there.
Well, Your Honor, that the only grounds for grounds for dismissal was that there was no duty for them to come out and speak. Under the ACA case in this court, there clearly was a duty to say, if you knew that accredited wasn't going to apply its own origination guidelines, you can't just tell me that, because the market understands. The market expectation, just as market expectation was a key factor in Abacus, the ACA case, is that if you tell me someone's originating them, that's it. The second set of misrepresentation.
I mean, I don't agree with that, I have to say. I don't think any of our cases say that. I think that's a huge stretch, but okay. What's the second thing?
There were a series of conversations, some of them documented in emails, some just by the testimony of the investment advisors, that they were told that the origination guidelines were being complied with. There was a cited in our brief, all right? The court didn't focus on those.
Are you saying oral representations?
Yes.
That's sufficient in this transaction, that someone told someone that everyone's on the up and up?
Yes, and there were also emails where we would write to them and say, where the investment advisors would write and say, what's going on with the guidelines here? Are these all originator guidelines? And they would say, yeah. They go, we don't have the answers, but the testimony was that yes, that's what it was.
Okay.
Okay,
Thank you.
you have 2 minutes.
First, just let me address, if I might, the underwriting guidelines issue, and then I'll come back to Champerty just for 30 seconds. The alleged misrepresentation that they're talking about didn't appear in the documents that they reviewed. They alleged there were misrepresentations about underwriting guideline breaches in offering documents. There were no statements about the underwriting guidelines in the only documents they reviewed, the preliminary term sheets. They did not mention.
Is there anything about, anyways, all it says is here are the originators, correct?
Undoubtedly, there were references to who the originators were. That's not what they
Is there
alleged
any
to be misrepresented.
representation about how the originators were looking at the loans?
No, there were not. And in fact, they've kind of given up that because they basically say their new argument is that we had some duty to affirmatively say that. That's just not the law. It hasn't been the law in New York. We didn't make a partial statement. We didn't have an independent duty. This was a German bank, a very sophisticated bank. We had no duty. So now they're saying, I think this is what the attempt of the Paulson argument was, that somehow they made an assumption about the transactions and that we had a duty to correct their unstated assumptions to us. That doesn't fly here. And so now they come, even though they can't find a statement about underwriting guidelines that was made to them in any document they reviewed, they now want to say, well, we've got new evidence in these five emails. And we shouldn't have to do it on this appeal because they didn't raise it. Two of them don't even mention underwriting guidelines. That's R3671.
Wait, you're saying they didn't raise those emails below?
No, they did not. And in fact, we asked repeatedly, what are the alleged misstatements? Emails are never
And there's
mentioned.
nothing in the offering documents that they reviewed that said, that made any representations about it.
That's correct, because they didn't, the only offering documents they reviewed were the preliminary term sheets, and they said nothing about compliance with underwriting guidelines.
So at the time, I just want to make this
Yes.
clear, at the time they invested, there were no representations in the offering documents or anything that they reviewed
Correct.
concerning that.
Correct.
Okay.
Absolutely.
Thank you.
Thank you. Could I just make one point on Champerty?
30 seconds.
30 seconds. The important thing is there wasn't a pre-existing interest because it was the supplementary deed that applied this 80-20 split relating to a loan that had been paid off. It, for the first time after the assignment, applied that to the recovery of this lawsuit. So it's the opposite of a pre-existing. It's an agreement that postdates the assignment. Thank you, Your Honor.
Thank you.
Briefly, Your Honor, if you look at the supplemental deed, I'll refer the court to record 3560. This doesn't create the 80-20. As I mentioned in my initial arguments, the 80-20 already existed. It says, for the avoidance of doubt, we will distribute the monies pursuant to, this was the mezzanine loan agreement, which has essentially the same language.
And was it just basically that you thought you could do a better job litigating it then?
Every lawyer.
I mean, no, it seems to me that that you thought that you would be able to do this better.
Yeah, and in fact, we, as defendants point out, we won below on an issue of common interest privilege. And as Your Honor knows, the basis for that has to be we have a common legal interest. Rio and IKB had this joint interest in seeing these claims maximized because that's how the cash was going to flow. And that, and the decision was, well, Rio doesn't have the documents, the witnesses, et cetera. IKB does, so let's do it this way to vindicate this right. And just very briefly, once more on the cross appeal, I do think that the statement in Abacus in the ACA case is very analogous to ours, and I'll leave it at that. There was no waiver. We cite in our brief, I think it's page 22 of our opposition brief below, footnote 13.
Did you raise those 5 emails
Not
below?
each of them,
Oh.
some of them, and some of the testimony, which reference here. And if you go in that footnote in the brief below, we did raise it, and we did cite basic yield, which is one of our main cases we cite here, so the argument was not waived. Thank you all so much.
Thank you. All right. People versus Joshua Armstrong. You may proceed whenever you're ready.
Good afternoon, Your Honors. Margaret Christ, law student intern with the Office of the Appellate Defender, representing Joshua Armstrong. Your Honors, this entire case hinges on a single second in a chaotic cell phone video of a fight. That sole evidence supporting the attempted robbery conviction in this case is not legally sufficient to prove the only disputed element of that attempted robbery conviction, namely an intent to steal property.
Well, he's definitely reaching for the pocket. I mean, you say in your brief that he was grabbing the leg of the pant, or the pant leg, I think, something like that. But it seems to me, I looked at the video, we all did, that he was reaching for a pocket. It may have been the wrong pocket, and perhaps the victim that day had already lost his wallet, like he already lost his cell phone, and because he was so drunk. But it did, I don't know, it seems like a reasonable jury, explain to me why a reasonable jury could not find that that was him trying to attempt a robbery.
Your Honor, at that 17-second mark in the video, you see Mr. Armstrong grabbing in the pants area of Mr. Diaz, but that is much more susceptible to an inference and much more consistent in the context of this being a fight, starting with apparently Mr. Diaz saying something to Mr. Armstrong and his girlfriend. That's much more consistent with action incident to a fight.
No, Mr. Diaz was pretty much out of the fight at that point. It seemed like. I mean, I don't mean to make light of it. It's not a very happy event, but he was knocked out, it looked like. He was leaning over the scaffolding.
Yes, Your Honor, and we submit that the video shows an assault here. But that's not the issue in this case because the people only charged first robbery and grand larceny, and then the jury ultimately only convicted on attempted robbery. And for that, we need an intent to steal property, which that 17-second mark in the context of the video does not show.
Wait, are you saying that a reasonable juror couldn't view that video and say, yeah, he's reaching into his pocket trying to see something? I mean, we all looked at the video, so You're saying a reasonable juror couldn't have come to that conclusion?
Your Honor, for the sufficiency standard as well as for weight of the evidence, but starting with sufficiency, we think that that is also susceptible to a reasonable interpretation of this being something innocent in connection with the attempted
But the
robbery.
jury, seeing that video, is free to reject that and interpret it in the way they return their verdict, right?
Yes, Your Honor, and the jury correctly rejected the prosecution's core theory at trial when they rejected the original indictment count of a completed robbery. They rejected the people's theory that this showed the actual taking of property. And I would emphasize as well that the only testifying witness at trial here who could have provided an additional eyewitness account of what happened or independent recollection was Mr. Diaz himself. But, Your Honors, he admitted multiple times on the stand that he could not remember anything after the first punch. He had been drinking whiskey for 12 hours. He didn't remember how he got to the subway.
Interestingly enough, there's a video, right? Because not every crime is committed with an eyewitness or with someone being able to remember or even somebody being alive to testify. So in this particular case, we have a video that was played for the jury, and they interpreted it that way. And I understand that on appellate review, we can look at that, but I mean, it is what it is.
Your Honor, we don't think that that's the 17-second mark in the video clearly shows that at all in the context of the lack of any other direct evidence in this case. The property was never recovered.
Perhaps that's why the jury, instead of convicting on a completed robbery, because the video doesn't clearly show an actual taking, but it does show, as my colleagues have all said, an attempt at going into pockets, or at least that's what it looks like. So why isn't that enough for an attempted robbery?
Because, Your Honor, there was no property ever recovered in this case. There was no motive that the people presented for Mr. Armstrong having any motive to attempt to steal Mr. Diaz's wallet. There was no forensic or physical evidence. And Mr. Diaz...
But I mean, again, those would be really good points. Maybe had this been a completed robbery and he was convicted on that completed charge, what was originally charged in the indictment. But as far as the attempt, right, we're talking about an attempt, which is the lesser included, and the video speaks for itself.
Your Honor, we think the video does not show beyond a reasonable doubt an intent to steal property in the context of this being a fight started by an exchange of words, apparently. But even if Your Honors agree with the people on this, we would still urge reversal on weight of the evidence, given the lack of any other direct evidence for this key disputed element. And to move briefly to the mugshot photo array issue, Your Honors, the photo array that the people admitted containing a prior arrest photograph of Mr. Armstrong was highly prejudicial because it clearly indicated that he had a prior arrest, and it was not needed for any of the disputed
How is this argument preserved in the court below?
Yes, Your Honor. This was absolutely preserved. On page 57 of the trial transcript, trial counsel raised this, and the trial judge explicitly rejected that objection, opting for a limiting instruction instead. I would also refer Your Honors to this department's decision.
Was there any objection to the limited instruction?
Once the judge rejected that objection, there were not subsequent objections to the limiting instruction, but the judge definitively rejected the objection to the admission of the photo array. And Your Honors, identification was not at issue in this case. The parties knew each other. Mr. Diaz provided the nickname to the police.
Isn't that all he had was the nickname? He only had the nickname, right? That's all he had.
Yes, Your Honor. Initially, he did only have a nickname. He also knew each other. They knew each other from the neighborhood. But in court, he then made an in-courtroom ID, and so identification was not contested, nor were the arrest procedures leading up to the identification or the arrest of Mr. Armstrong, which further distinguishes it from cases in which sometimes these types of photographs are allowed in. Thank you.
All right, you'll have time on rebuttal. You may proceed.
Your Honors, and may it please the Court, Anna Notchik for the people. Defendant's guilt of attempted second-degree robbery was proven beyond a reasonable doubt at trial, with evidence that included a cell phone video showing the defendant repeatedly punching the victim.
Was that cell phone video properly authenticated?
Your Honor, it was. It was authenticated in multiple ways. The victim testified that he was in the area that the video was taken, at the time that the video was taken, that he recognized himself a defendant, that he was having a conversation with the defendant, and that defendant punched him. Surveillance video from the surrounding areas also authenticated the video because it showed the defendant and the victim in the same area that the video was taken, in similar clothing.
Apart from authentication by the victim, should the victim have been allowed to talk about what was in the video after the victim was basically knocked out? The defendant makes the point that he's a third-party narrator. That's the term used in the brief, and I think that's apt. Why was he allowed to testify about what he didn't know in the video? Because he was out of it by the time a great deal of the video transpired.
Well, he did remember initially being punched by the defendant. He was able to testify about what was in the video. He was watching it in real time and explaining what he was describing in real time. And the video, any objection to the authentication of the
Why
video.
was that necessary? The jury is watching the video. They can see for themselves what's happening in the video. They don't need him to say, and there I am falling on the floor after he punched me in the face. I'm seeing it. We don't need that.
Admittedly, the jury was watching the video, but any argument in that and to that regard is unpreserved for this court's review. Defense counsel never objected to the admission of the video when it was actually admitted after it was subject to connection. So any objection or any arguments as to the authentication of the video are unpreserved. Moving to the...
What we're talking about is not the video, it's the allowing the complaining witness to talk about things he doesn't remember because he's knocked out.
Your Honor, I also don't believe there was an objection to that. I may be mistaken, but that would also be unpreserved. That's also, as I've mentioned, the video was properly authenticated. The jury was able to see it. They could have come to different conclusions than what the victim was testifying to, but all told, the video was properly admitted and unauthenticated. The jury was able to view it and come to the conclusion that the defendant was rifling through the victim's pockets in an attempt to steal. As to the photo array, it was properly admitted into evidence. It was not unduly prejudicial. It did not show the defendant in shackles or handcuffs. It was just from the shoulders up. He was in civilian clothing. Even if there was any prejudice from that, it was eliminated by the limiting instruction.
And the gratuitous comment by your police officer during direct, the mugshot.
Well, just
which every officer knows they are not supposed to say. Come on.
Well, just to clarify, he was talking about the initial photo manager system.
You and I both know that in a criminal case, unless the defendant has taken the stand, you can't say that, right?
He should not have said it.
Okay.
However, it was in reference to the initial photo manager system where the defendant was not identified. The defendant was later identified in a different photo array, which the officer did not describe as a mugshot photo array. If there are no further questions, we ask that you affirm.
Thank you. You may proceed.
Thank you, Your Honor. Just briefly, first on the photo array. This photo array, regardless of the subjective intent of the officer on the stand in referring to the mugshot photo array, was highly prejudicial in that context. The jury, shortly before seeing what it was a classic mugshot photo array, the jury also heard in court the phrase mugshot photo array. And we think that the array speaks for itself. It takes no legal training to immediately recognize the individual photos as well as the 6 altogether as classic mugshots in framing, orientation, and composition. Second, on the video, I would just emphasize on legal sufficiency that if Your Honors conclude that the video is equally consistent to the interpretation of it, of what the people say, and with Armstrong trying to pull down Diaz's pants in an effort to humiliate him, if those are equally susceptible, that's still legally insufficient for the attempted robbery conviction here. And Your Honors, to pick up on the questioning a moment ago, the video itself when being played while Mr. Diaz is testifying, it's clear in Mr. Diaz's testimony that he was offering no independent recollection of what was going on. He was simply akin to a third-party narrator for the jury. He admitted he could not remember when he had last seen his wallet that day. He woke up the next morning, discovered it was missing, could not remember how he got to the subway or anything after the first punch, including this critical moment that allegedly shows attempted robbery in the video, but that is not that's not sufficient for the attempted robbery conviction here. Thank you.
Thank you. And thank you both. You did a wonderful job, and good luck to you on your admission.
Thank you.
All right. Jacobson versus Cidio. Justice O'Neill Levy is recused. If we should have a tie, the court will follow its rules and vouch in a judge.
Good afternoon, Your Honors.
Good afternoon.
May it please the court, my name is Ravi Batra, and I have the sacred privilege of representing then Justice Jacobson, who's in court, a respected member of the independent judiciary who was pilloried in New York Post due to these screener defendants maliciously leaking their per se false and defamatory mixed opinion.
I'm glad I stopped you there, but
Sure.
let's assume we agree with you on this mixed opinion issue and that claim cause of action should survive. Why isn't it time barred?
Well, first of all, law of the case, Judge. There's no cross appeal by the defendants, and 5 months after the Second Circuit ruled, we filed a state action, and you were given 6 months. So footnote 3 of Justice Knox's decision makes clear that our timing is correct, and the fact that they continue to argue in their opposing brief what they didn't cross appeal on, and is already law of the case, two things are law of the case: that the leakage could only have come from them, and second, that it's timely. They never cross appeal, so therefore it's law of the case. So if I might continue, Your Honor.
Well, let me just, before you continue with that, in the federal action, there was a notice of appeal filed, right? And admittedly, the notice of appeal mentions the state claims. However, moving beyond that broad notice of appeal, was that claim actually pursued in briefing and then decided by the Second Circuit?
Your Honors, if I might, we had also asked for leave to replead. And so that matter was, so the replead covers federal and state claims, and it went up to the Second Circuit, and then they affirmed the court below, and then we started within 6 months, actually 5 months, the state action. And the court below found that we were timely, and there was no cross appeal. So I think we ought to be able to move off that topic, because I want to make 3 salient points, and starting with mixed opinion.
You can move on. The fact that the court below held doesn't mean we have to hold.
Okay, then we'll
go
continue.
ahead.
No, then if Your Honors are not convinced of that issue, then we'll stay on that topic. So the point is that footnote 3 of Justice Knox, it gives you ample grounds, and even if you look at the direct record, which was filed by the defense, that when we took the appeal to the Second Circuit was of everything.
So, no. But when was the last time that a court, a federal court, issued a decision on the defamation claim? The district court was the last court,
The district
correct?
court declined supplemental jurisdiction, so they never issued a decision on
I'm
the
not
merits.
saying I'm at the, right. But
Okay.
so that's when that claim ended. Unless you appeal that claim
We did.
and perfect your appeal. The fact that you put in a notice of claim that says we appeal everything isn't sufficient. Can we agree on that?
So the notice of appeal appealed everything. And,
Again, so I'm saying that that's not sufficient.
okay,
So did you substantively argue that anything about the defamation case on appeal?
we asked for leave to replead, which includes both.
And that was denied, right?
Right.
Okay,
So
so
once it's denied by the Second Circuit, we then started here in 5 months. Because imagine
that's
the
correct.
message.
I don't
Imagine the
think
message
that's
to the bar that it gives when you take an appeal. Not just this case, any case. You know, it's like the 30 days for notice of appeal only is triggered from a notice of entry, not because an order is entered, but from notice of entry. The notice of appeal here, the bar relies upon the fact that if you took an appeal on everything, and then however it progresses and the appeal is perfected, and then whatever transpires, not only in the briefing, but in the argument, because just like I came here saying it's law of the case, we're done, and if you're not done, we're not done. So it's very simple. So if the Second Circuit, and one of the panel members of the Second Circuit was Judge Wesley, who was a Supreme Court judge, went to Court of Appeals, so fully aware of what occurs. So if they decline not only the federal counts, but they decline supplemental jurisdiction, and they decline the request for leave to replead, and the leave to replead includes both, that's a belt and suspenders as far as counsel to the plaintiff. There's no other way to do this. Otherwise, you'd end up with take an appeal for everything to the Second Circuit and then start a state action. I mean, that's a little bit of schizophrenia I haven't yet achieved. Maybe someday I will, but not yet. So I believe it should be rock solid ground, and I think Your Honor should make it clear, because otherwise, it's
If the federal court, let me ask you one more question. If the federal court declines to exercise supplemental jurisdiction, doesn't that mean it's dismissing that claim?
I'm sorry?
Dismisses that claim.
No, they're not. They're declining supplemental jurisdiction, which they have a choice. If they can decline, they can dismiss your federal case, right? Your federal counts, and still retain jurisdiction on state claims.
But you can't continue on in terms of ending the case, you can't continue on in the federal court if they decline, right? So there's nothing.
No. If they decline, Your Honor, if they decline the federal counts, they still have the power to retain supplemental jurisdiction of state claims. If they decline the federal counts and they decline supplemental jurisdiction, okay, the first one they have an absolute right to do. The second one, it's discretionary to them, whether they want to keep the state claims or not. Here, they declined the discretion to exercise jurisdiction over state claims. And the same thing was upheld by the Second Circuit, including not granting leave to replead. So because we had asked for leave to replead, which is for both counts, they denied that. We started the case in 5 months, which is why we're timely. Can I get to my larger?
I will add an additional time on your rebuttal, since this issue took up so much of your time.
Thank you, Your Honor.
Okay?
Your Honors, George Carpinello, Boyschiller, Flexner for the defendants, respondents. To answer the questions Your Honor asked, yes, the district court dismissed the state claims, saying we're not going to exercise supplemental jurisdiction. Although the notice of appeal referenced all the claims, his brief did not.
But what about your adversary's argument that they moved for leave to replead? Why does that not encompass this particular issue?
Because the motion to replead rested only on the federal issues, and I'll read from the brief. This is his motion to replead. His argument is the district court should have allowed Laura leave to amend her pleading in any element was missing, and here's what it says. The underlying determination to dismiss Laura's federal claims as pled in the first amended complaint was incorrect on both the facts and the law.
And did the plaintiff move to appealed the denial of supplemental jurisdiction over the state claims?
No, her brief is entirely devoted to her federal claims.
So there's nothing, once the district court dismisses that claim, that's it.
That's it. Under the VD case and other cases,
right,
the 6 months begins to run when the last federal court addresses those issues.
Which here would have been September 29th.
Which here was September 29th. That's exactly correct, Your Honor. And so his libel and slander claims are time barred. And he says, how could I deal with that? Well, he could have filed his state case within 6 months of September 29 while he pursued his federal claims on appeal. He knew that the federal district court was not going to hear the state claims, and then he appealed the federal claims to the Second Circuit. He was done in federal court on his state claims. He should have filed within 6 months. He did not do so. They're time barred. Briefly, with regard to the other claims, Your Honors.
Counsel, can we talk about the contract claim against the JSC defendants briefly? Was there a letter contract created by the letter sent by, I think it was Mr. Edelman, saying that, yeah, we won't publicize the non-approval by the screening panel if you withdraw? Was that a contract?
No, that was not a contract, and because all that she alleges is that he violated the committee rules, which are to keep the application confidential. And allegedly, someone on the committee, allegedly, and of course we deny that, disclosed that to the public. The case law is very clear that a violation of the rules of an entity, whatever the entity is, if you're not a member.
Does the JSC have any independence from the party apparatus in Kings County? It's a creature, isn't it a creature of the party? I mean, the party had to create it, right?
It is a creature of the party. It's created by the party.
Okay.
So it's not like a separate corporation or separate unaffiliated. It's just some people in the party join this committee like you would in a corporation if maybe you're on the compensation committee or something. It's similar to that. It doesn't have any independent existence, does it?
It's an unincorporated association.
The party, right?
Right, but the rules she's citing, the rules she's relying on are the rules of the committee.
I'm just trying, right. And now the party's no longer a part. The party is no longer in, right?
Correct.
So
those confidential rules, who are they supposed to benefit?
They're supposed to benefit,
the party?
no, unquestionably, they're supposed to benefit the applicant. And the rules themselves dictate that anybody who violates the rules is subject to suspension or exclusion from the committee.
That's great. That does nothing for the person whose privacy has been violated, right?
It does not.
You know, this case is really frustrating, right? Because we have no choice as judges. If we want to be a judge, we have to go before these screening panels. And we rely on these screening panels to do their job the way they say they're going to do their job. And when you don't, what you're standing here arguing is we have no recourse. Too bad. If we mess up your reputation and sully your name for years to come, too bad.
Well,
is that the response that we are to give our colleagues all across this state? Go before judicial screening panels at your peril?
Well,
That's what it sounds like.
Well, I'm only reciting the law. The law is very clear on this.
That may be well and fine.
But let me add an additional point that Judge Knock held, even aside from the fact that there may be a contract, there's no breach of contract claim because the only loss is reputational. And as the appellant herself admits in a reply brief on page 27, there is no recovery under contract for pure reputational damage. Now, if she had come forward, if I may just answer,
yes.
If she had come forward with evidence of a loss of a position, a concrete harm, she would have had a claim. But arguably, if she'd met the other conditions, reputational harm is not recoverable. That deals with both contract and promissory estoppel. And finally, if I may, on the libel and slander, separate and apart from the statute of limitations, the case law is very clear, as Judge Knock held, that you cannot bring a cause of action for the fact that people publicly comment on the performance of judges.
Well, here's the thing about that, counsel. I don't know why this wouldn't be considered a mixed opinion, because where else would this information, some statements may be opinion, yes, but where else would the information about someone being a judicial candidate being found unqualified, where else would that come from other than the party?
That could have come from a lot of sources, including the appellant herself. And it's really not in the record at this point who actually talked in the courthouse about
Look, again, I just, you know, we typically, and I probably shouldn't say this, but judicial screening panels all over this state should pay real close attention to this case. Because I know how much you want the candidates to appear. Well, if you want that to continue to be the case, this cannot happen again.
Let me just, Your Honor, if I could. The fact is, first of all, we're at the motion to dismiss. It's not clear who disclosed that she did not get.
So then you're saying this should go to summary judgment, maybe?
No, I'm saying for the reasons in our brief, she fails to state a cause of action. But to answer your factual question, there's no evidence that any of the comments came from the committee, and there's no evidence that the fact that she didn't get approved for reappointment did not.
Yes, because after giving up her judicial seat, she would go and spread the very thing she was trying to avoid by forfeiting it. That argument makes no sense, but I understand why you make it.
Thank you, Your Honor.
Counsel?
Contrary to what has just been represented to the court by defense, on page 163 of the record, point 10 of my reply brief to the Second Circuit, the point header is, the district court should have granted Laura leave to replead her pleadings, which is state and federal claims. So it was brought up. We were seeking jurisdiction of one, so that was the focus of the appeal, but we never gave up the right for state claims, and it's right here on page 163. So why they continue to make this argument, I have no idea. But if I could proceed.
Good, I gave you some more time.
Second, he cited page 27 of my reply brief that we can't get contract damages. Except that when you have per se defamation or per se libel, professional, reputational, then special damages are presumed. So that argument doesn't apply. Let me get to my main arguments, if I might. The defendants essentially want absolute immunity because they are attorneys disclosing confidential information that is both false and which they created, they and they alone created, as screeners. Now, the court below got lost in the pure opinion issue citing Jack Newfield in Rinaldi. Well, let's look at that. Rinaldi, Jack Newfield's a reporter, he's an outsider looking in, and whatever he says, it is pure opinion and we need to protect it.
So wait,
However,
can I just quickly ask you, what do you think is not pure opinion here?
That she was found unqualified or not qualified.
Is that not the truth?
Thank you, Your Honor, for raising it, because I didn't bring that up.
It's not only that she was not
The
qualified
answer
at
is
this
no,
time.
it's not true, because while Edelman wrote the letter in May, there's two Edelman letters. Edelman 1 says you're not qualified, even though that ranking doesn't exist in the rules. So if you look at Rule 9.
What is the ranking? The ranking is not qualified at this time. Is that the point you're making?
Well, that's correct. So not qualified at this time versus not qualified. And second, as an incumbent, which the plaintiff was, she was entitled automatically to being qualified, but not necessarily recommended. So, in fact, those rules mirrored the Manhattan screening process because New York County had 3. You qualified, then you pick 3. Brooklyn went with 5. But you had to be qualified before you could be recommended. And as an incumbent, she was automatically qualified because only the CJC can take somebody off the bench or say you're not qualified. Screening panels don't have that power. So the fact is that in Edelman 2, he changes and admits that her ranking actually is not recommended. And by doing that, he's admitting the falsity of his Edelman 1. He admits the falsity. And the fact that they gave her a ranking of not qualified, which doesn't even exist, is the proof of the malice. Because she had cut, as a judge sitting on the bench, she had cut their legal fees, Edelman's and Steve Finkelstein's. She was brought in as an acting surrogate to clean up the mess that sometimes happens in courts. And, there were political corruption problems, et cetera. She was brought in as double duty. In addition to sitting as Supreme Court judge with the same calendar, she was brought in as acting surrogate. And they accused her of being lazy. Okay, and she was brought in multiple times by OCA. So going back to my 3 points I want to make, which is...
I'm going to give you another 45 seconds.
Yes, Your Honors. So let me do this by memory at this point because I can't even seem to find the page that I had summarized this for. Oh, here it is. So one, mixed opinion. Every opinion issued, whether it's not qualified at this time, et cetera, or recommended, by the screeners is by definition mixed opinion because they're the ones in the kitchen. So just like a teacher issues a grade, that grade is based upon facts not known to the public. So it's not Jack Newfield, they're insiders. Second, under traditional law, she meets the New York Times v. Sullivan because she can prove the falsity and she can prove the malice, and hence has a cognizable cause of action. What we're requesting this court to do is to issue a mandate that the matter be answered. As counsel just said, we need to have more discovery as to who did the leaking. And with your case of matter of Giuliani, where Giuliani had some speech rights, here's a case of first impression. Your Honor, Justice Manzana, to your point about screening, our entire system needs clarification from this court, from this panel, because under New York Times v. Sullivan, the defendant who is being sued in any defamation case has some speech rights, some free speech rights. No one has absolute free speech rights. You can't yell fire in a crowded theater. But here, and that's why this is a case of first impression, these defendants had zero free speech rights, because when you activate Rule 31B, which by the way is attached to Edelman's first letter, and it's on page 569, it says, if you withdraw not your application, but your candidacy, which means you're giving up your constitutional right to go to the screening nominating convention, then we will say nothing about you ever. So, and if she hadn't withdrawn her candidacy, what was their limitation? Rule 16 says it. Name, rank, and serial number letter. I've served in that panel. I know what this is about. You issue a name, you issue the ranking, and whether or not they can be recommended or not. That's it. You don't get to say why. You don't get to say they're great. You don't get to say they're lousy. You don't have any opinions to offer. So Rule 16, without her withdrawal, is the limit of their speech rights. And with 31B, they have zero speech rights. So I would like, Your Honors, to issue some guidance to the court below and to the bench and bar, as well as our system of justice, that screeners, in this case, where you have a withdrawal, as the plaintiff did, to let bygones be bygones, just let it go, may be subject to strict liability because they have no speech rights.
Thank you.
Thank you very much, Your Honors.
Ashanti versus City of New York. You may proceed.
Thank you. Good afternoon, Your Honors. May it please the court. Philip Young here on behalf of the city appellants. This court should...
Counsel, I have one question, and before you start off, I just will help me clear up something. When was Mr. Ashanti referred over to COIB?
In May 2017.
And how was that done? Was that by a letter? Is it an email, a phone call?
It's in the record. I think it's page 1283. It's an email from the law department to an attorney at COIB.
Thank you.
So the Supreme Court erred in denying the city's motion for summary judgment on Mr. Ashanti's race discrimination and tort claims. I'm going to start with the race discrimination claims. Those claims fail out of the gate at the prima facie stage because the initial facts as described by Ashanti do not raise an inference of discrimination. Ashanti conceitedly does not raise any direct evidence of discrimination. The sole evidence he relies on are these two purported comparators, two non-black law department attorneys who were arrested for DUIs but not fired. The problem with that evidence, though, is that those comparators are not similarly situated to Mr. Ashanti. Mr. Ashanti had a significant and substantial disciplinary history, as the members of this panel know. He was disciplined in 2017 after he committed 3 serious violations of the conflict of interest laws. They were referred to the Conflict of Interest Board. He was penalized. This court confirmed it. The comparators, and then for that conduct, for those violations of the Conflicts of Interest Board laws, he was essentially given a negative performance evaluation by the law department. Executives held 2 serious meetings with him. They put a letter in his file and made him attest to his understanding of the law department policies and procedures. There's no equivalent disciplinary history in the record with these 2 comparators. On top of that, the comparators' conduct...
So he would have no way of knowing that at this stage, would he?
He does, Your Honor, because there was discovery here, and there's evidence in the record that he got in discovery showing the annual performance evaluations for these two comparators. And there's nothing, he points to nothing in there that would suggest that there's a disciplinary history of any time. And then
Wasn't there also another African-American worker who was arrested and was fired? So there are three comparators. There's the two whites who were arrested, not fired. There was another black man who was arrested and fired, and now Ashanti who was arrested and fired.
So the only evidence in the record about that employee, Your Honor, is from deposition testimony, and the law department executive who was deposed said that she did not know when that individual was fired in relation to his arrest. And also, very importantly, he was arrested for mortgage fraud. It's a serious felony. He was being investigated by the Department of Justice. It's very far afield from the DUIs that the two comparators.
You think mortgage fraud is more serious than a DUI?
Well, it's a felony, Your Honor, and these DUIs were misdemeanors.
Yeah, but a DUI, somebody could get killed. A mortgage fraud, a bank loses money and finds a way to recoup that. So no, I think.
Absolutely, Your Honor. They are serious for different reasons, but I think the critical point is they are not of comparable seriousness with respect to Ashanti's conduct, which directly related to his job with the law department. And it was the second instance in under a year of him misusing his official city position for personal benefit. So for that reason, these two comparators are simply not similarly situated to Ashanti here.
Was it really a misuse, though? You could argue that he showed his ID from the Corporation Counsel just to say, yeah, I work at 100 Church Street. I need to go down there, you know. And also your companion officer just said, yeah, go. So, I mean, how did he misuse his office in this instance with Officer Shapiro?
He misused his office because the charter and the Conflicts of Interest Board have been quite clear that you cannot use your city position even with displaying your ID to obtain any type of personal benefit. That's something that law department attorneys
He did have to walk down a street to get to his building, right?
Yes, Your Honor.
So what we're talking about is he should have crossed the street and gone around these officers instead of asking for permission, which he did do and get from the first officer. The fact that the second one didn't know that is where we have the problem. I saw the video. Okay? I saw the video. This arrest shouldn't have happened. All right? It should not have happened. We have an officer who went ballistic because you're not listening to what I say right now. And so we're going to escalate you went into Dunkin' Donuts. By the way, the video you gave us, there's an officer who goes into the Dunkin' Donuts right as Ashanti's walking out.
Your Honor, with respect to the tort claims, I think the video evidence is quite clear that regardless of whether the initial officer gave Ashanti permission, once Ashanti encountered Officer Shapiro and Officer Shapiro told him to turn around and return to Broadway, and he didn't do that, he argued with him, he crossed between two parked cars to evade the officer. The video shows
You
him.
say to evade the officer. Maybe he decided to cross the street and walk on the other side of the street so as to avoid these officers. That officer followed him into the street and confronted Ashanti, not the other way around.
Your Honor.
Slapped his breakfast out of his hand. I mean, come on.
So 2 points on that, Your Honor. I think first, with respect to the question of probable cause, Ashanti's subjective intent is irrelevant. What matters is it's an objective, reasonable officer standard from the moment on the scene. And then second of all, I think that video quite clearly shows that well before the officer engaged in any type of physical contact, Mr. Ashanti crossed between two parked cars to avoid him and took 6 or 7 steps in a
Again,
westward
you
direction.
say to avoid him. I say he changed his pattern of walk. That doesn't mean he was doing something wrong.
Your Honor, in combination, the disobeyal of his order, in combination with the additional work that Officer Shapiro had to engage in to cross across the street, block his path, and direct him back to Broadway is sufficient under appellate division case law for probable cause to arrest for obstruction of governmental administration.
Okay.
Good afternoon, Your Honors. May it please the court. Excuse me. I think what is being asked in this case is for this court to look at a set of facts which can reasonably be drawn towards plaintiff or towards defendants and simply draw them in favor of defendants. That's what this appeal is about.
I just want to ask you about the comparator information. So, because assume for the moment that we think that the city proffered its non-discriminatory reason. You know, he did have a significant disciplinary record. And then, so to raise the in inference of discrimination, you bring up the two comparators. So how are those two comparators similar to the plaintiff?
Well, the case law is clear that the issue of similarly situated is an issue of fact, generally speaking. The criteria for governing similarly situated is not identical. It typically looks at same rank, same supervisors, same position, same tenure, same set of performance evaluations. None of those things are disputed here. The issue is defense counsel's use
Did those other two comparators have disciplinary?
I would submit, Your Honor, and I respectfully no.
I just want to know whether they did or
not.
didn't. And you did discovery on that, and you saw this was their thing, right?
The only
they both got
discovery that was provided-
DWIs.
The only discovery that was provided to us was their evaluations.
Well, no. What else would you? I mean, you could have asked for
No,
whatever
that's fine.
you asked, right?
That's fair, Your
So,
Honor.
Right?
There is no evidence in the record that they had any disciplinary history. What I would submit to this court, Your Honor, is that defendants, it is not undisputed plaintiff's disciplinary history. First of all, COIB and the oath is not the city. It is not the same thing. They refer to an email referring these cases to COIB. There is no such evidence of referral. All we have is decisions.
So in your opinion, or to your knowledge, how would this information have gotten there? Or do you know, is it someplace in the record as to how COIB actually got this?
Well, Your Honor, the city has many arms, as Your Honor knows, and this was actually brought to Mr. Ashanti's supervisor's attention by an attorney who was working for the city in connection with his wife's litigation. That's how this issue was raised in the first instance. I can only speculate how it made its way to COIB, but I can say that let's set that aside. The fact that the city themselves, the only discipline that the city meted out upon plaintiff was a letter in his file, and his evaluation from that year was exemplary. He was called, and I quote, a credit to the city and a credit to his clients. That is not someone whose disciplinary history...
If this was referred to COIB in May of 2017, and then he signs that acknowledgement letter in July of 2017, and all they choose to do at that time is not fire him, but, you know, just stick a note in his file. But it was still reported in May of they've done their part, right?
If that's fine, Your Honor, it still doesn't address what I believe Your Honor raised is that the second issue of discipline, the first issue of discipline is immaterial unless you find that in connection with his arrest, he was also misusing his identification. And the fact that if we're gonna say that they referred the initial instance to COIB, why not refer the new instance to COIB? They certainly could have. COIB actually addressed.
But at that time, that's when he got terminated, right?
Exactly. And why not, again, we're not just dealing with an inference of discrimination based on comparator evidence. This court has found that the reasons proffered by defendants, if they're subject to disbelief, that can also raise an inference of discrimination. He asked specifically at the time of his termination, why am I being fired? He was never told. This was never disclosed to anyone. DCAS asked 3 times or 4 times Ms. Trufant directly to provide instances of past disciplinary conduct, records, reasons for his dismissal, including prior instances.
wasn't there information in his records of him being disrespectful to his adversaries, disrespectful to judges, disrespectful to his colleagues?
His adversaries had a
I'm just right, but
Right.
it's in the it's
But
not that there's nothing in the record with
point is,
it's
Your
not
Honor,
that he's
none
a
of those reasons are
Let me just
cited. I'm
finish.
sorry.
That there is discipline. He has a disciplinary record that's above and beyond the big fine he got for conflict of interest, right?
But I'm willing to concede that, Your Honor, for purposes of this argument. The point is that
You're saying it's a fact issue.
if
let
yes,
it
if
go
he's
to the
not
jury.
fired based on the disciplinary record, then it means nothing. If they're after the fact saying, "Oh, it's because of the disciplinary," but at the time when
Maybe
they had
they're
the
being nice at the time, and at some point they figure it's enough is enough.
Well, Your Honor, I think they have a duty when DCAS is asking them specifically when it pertains to unemployment benefits, and they're asking them pointedly, why was he fired? Was he fired because of disciplinary? Was he fired because of misconduct? Did he voluntarily leave? And they lie and they say he voluntarily left. And we don't ask why anyone leaves, making it seem like he just got up and said, "See ya, I'm going." And then when they follow up and say, "Why are you not providing us any information?" they still do not provide the reason for dismissal. That and that alone, regardless of anything else, take away the comparators to me, which are the smoking gun in this case, but the fact that they don't contemporaneously document, how easy would it just be to say, yeah, he's got a disciplinary history and he did the same thing over here. Why not say that? They don't. That, to me, a reasonable jury under the lower standard of the city human rights law could certainly find a reason to disbelieve what the city is claiming the reason is now for his dismissal, and find that in connection with the fact that there's 4 individuals here who were arrested, 2 of which were summarily terminated, 2 of which were not, and the only 2 that were not were non-black employees.
Thank you.
Just a couple of,
Can I just ask you, he wasn't terminated, correct? He chose to resign.
yes, he
Okay,
resigned.
I
in
just
lieu-
wanted to make sure that I understood that because he wasn't terminated. He chose to resign.
Yes, that's correct, Your Honor.
Is there something in the record that he chose to resign to avoid being terminated? I mean, I think that's the reason.
Right.
Absolutely. We're conceding there was an adverse employment action here.
Okay. Right.
Certainly. It was a resignation in lieu of termination. So 2 quick points. One with respect to the reason given at the time of termination. On the phone call with Ashanti, no reason was explicitly given. But just after this event happened, he received an email and a letter from the law department telling him that he was being suspended because of this incident that had just happened. He clearly understood that. He sent an email.
So why not answer the question to DCAS that was asked multiple times?
Your Honor, I don't know the reason. It's not in the record, but those emails do not rise to the level that would allow a jury to infer discrimination from the circumstances here. It doesn't make, the inference that Ashanti is seeking the jury to draw just doesn't make sense in that context, because revealing that he resigned in lieu of termination would not have revealed any type of improper motive on the part of the city.
Precisely, which is why the question should have been answered if that was the answer. But thank you.
Thank you, Your Honors.
And it's good to find me, Josh.